another bill is
highest in the world. Is that correct?
That is correct. Yes.
Not entertained or
no, it means compliant.
if it could not have been maintained, where's the question of issuing
No,
such
that's I'm saying High Court decided. I'm not
High Court?
I'm
High
not
Court
saying
was
Malaz, that your lordships will be inhibited by that technicality.
High
I'm
Court
saying
decided.
issues of far-reaching importance.
There are two choices.
Yes.
In the light of the observation made, the submission made by the solicitor. One is to consider posting it in January.
Yes.
Which means this will give the legislature ample time to bring in a law. What are we here trying to, is it establishing a point or securing the rights of the users? Now, if the legislature is going to come forward with a comprehensive law, which may be a solution to all the problems, we need not be breaking our heads to, establish the point in law as such. If there is no likelihood of, if that's, I think, a reasonable time we are giving. We are putting it, say, somewhere in the second week of January. The other is to put it at the earliest, which can be in the second week of November, and proceed to hear the matter.
So may I respond to that? So first and foremost, I don't have a problem if the matter is fixed in the second week of January, but it ought to be. I can only request it ought to be on the understanding that there will be a final hearing on that particular date. Because it can't be that in January, then we are again for directions just to another 3 months.
Either there is a law, or
either there is a law, yes,
or we will begin hearing.
Yes, because the burden of our song is also until a law, what should be the norm required? No, that is ultimately, because how can we prevent Parliament from, or whoever, whichever the appropriate legislature is, from making a law, and that can always be amended because there will be an element of experimentation. So I have no problem with 15 January, but I will only request that then let it be in 15 January, whatever date or thereabouts, fixed for final hearing. We will file our written arguments before that.
All pleadings
Yes,
we'll go on with the case.
Yes, I agree.
But my stand is clear. Howsoever big a multinational is, if you are operating in India, you have to comply with the laws of India, and you have to treat Indian citizens with equal degree of privacy which you are treating others.
That's true.
But the difficulty is, I'm not making it WhatsApp centric. It should be citizen centric.
That's correct.
And no, it's not correct. Many of the directions of the central government are flouted. Many of the legal directions under statutory regime are flouted. Yeah, we are arguing one matter, filed by one intermediary. I will not name. Mr. Datar is appearing in Karnataka High Court. So, they may not feel that since we have a global presence and we have kind of a...
All right. We learn it.
I have in the corrected
My lords,
mine is a writ petition where pleadings are not complete. It's also a correlated issue of data localization, where our private data should be stored within the norms of this country and be made available to regulators and courts as and when called upon for. There's no law to that regard. All the information pertains to us, WhatsApps, whatever, is all being stored outside India. So therefore, the compliance with courts orders and regulators is pure voluntary in nature by them. So my prayer is, Lawz, in terms of information privacy as recognized, Lawz, by bench of this court, the data should be stored in India and made available to regulators.
That's
my lord,
issue.
we have filed an impediment intervention.
you are here.
Sorry.
We're searching for you. Yes.
Sorry, my lord, we have filed an impediment intervention application that has been accepted by my lords in 2017. So Vishwanathan had appeared on our behalf in my lords will see the orders. We had made detailed arguments.
Who's that?
Mr. Vishwanathan for Internet Freedom Foundation.
Huh?
Internet Freedom Foundation, my lords, it's a digital rights organization. So my lords, we had filed our petition is also on our intervention application is also on record. My lords, we had also filed an application for directions given the 2021 privacy policy. However, despite many times trying to get the matter listed, the matter was never listed. Our IA was never listed. If my lords, I can just request my lords to issue notice in our IA I understand that pleadings in their IA are complete. So, my lords, we don't even need pleadings to be complete, but just so that we can argue on the 2021 application, my lords can just take note of our intervention application number.
What do you say? Does anyone have any objection to her?
No, they'll assist.
I think-
court,
I think
they
the
can
first-
always assist the court.
She can always assist the court. My request to your lordship, let the matter come up, and at that time, whatever request is made, your
We
lordship
will
will
bear
consider
that
it.
in mind. We'll give you
Yes,
all
yes.
note.
My lords, we just note this.
Yes, all the parties, I mean,
Yeah.
will intervene, so that,
There's no issue.
not impeding.
Yes, yes.
No issue.
Some kind of, personal.
Fair enough, fair enough.
So there are two dates that I find. Let's read the calendar. I think 10th and 17th of January are Tuesdays.
10th of January,
17th.
Yeah, whichever date which your lordship for
17th.
final disposal.
why 10th of January is inconvenient?
Well, there'll be lot of miscellaneous.
There'll be a lot of holidays, bro.
Holidays in
Sometimes
between.
there'll be a lot of holidays.
That's why I said.
All right,
I
17th,
don't mind 10th.
17th January.
Come,
Yeah, Pongal.
Yes,
on that day, it's understood.
yes, it'll be for final disposal.
It is for final disposal.
And your lordship may indicate some date, say a week
The
before.
first week would
Where
be a
short
miscellaneous.
notes of submissions can be filed.
But who will actually, all these constitution-based matters, we would like to have a common convenience
That we'll do, Manas.
so that you'll have to get together and put it together. So
No,
that-
we'll ask Brinda to take it up.
Huh?
We'll coordinate
But
with
with Mr. Kanu Agarwal and
Brinda.
Brinda.
Somebody from the,
Lordship may note, we have to record Kanu Agarwal and Brinda Bandari will coordinate to make a convenience.
that's right.
Lordship
So
so
documents and then they can compile my matters. In the.
In all matters, they have to complete whatever.
Yes.
matter-
I don't know, his thing is that he wants all the data to be localized in India. That's
Whatever, pleadings to be completed by end December,
We will insist that briefing should be completed
by 15 December.
15 December, exactly.
Before the vacation.
We will
Yeah,
have
so
a
1 month.
clear idea.
Yes, yes,
And then somebody will actually put together a
Yes.
common
We'll do
convenience
that.
audio.
We'll do that.
So we don't have to look to many volumes.
Reflecting all views, Manoj, so that pagination is continuing.
Who will undertake that task?
My
So
lords,
that's Kanu Agarwal and Brinda Bandari.
Kanu.
Huh?
I'll do it with Mr. Agarwal.
Just give the name of.
Kanu Agarwal, Manoj, KANU.
Having heard, no, first of all, so when this matter came up, it's Solicitor General. Sapita, the matter came up suddenly,
yes.
was yesterday night. It's pointed out, this is a case where Parliament had introduced a bill initially, but for good reasons it was withdrawn. It is further is sufficient that the stand of the government of India is
There was a draft. It was.
It's not introduced, Manoj, if I remember correctly.
It was.
It
was-
was,
It was
went
introduced.
to a
It
parliamentary
was
committee.
introduced in December
But
2019.
I'm not aware, so it may not be possible for me to make an accurate statement.
Look, my lords, it was introduced in December 2019. It got referred to the joint parliamentary.
If my learned friend says it must be so.
It was
We have
tabled.
I'm relying
We have
upon
the
Manoj, the
withdrawal.
last
It
interview.
was
sir.
tabled, it went to the parliamentary standing committee, then it was not introduced formally.
introduced. So it is tabled.
Tabled. Manoj.
Tabled it.
As the bill was tabled,
And withdrawn.
bracket, you may just say.
Later withdrawn.
Council for WhatsApp.
That's correct.
No, your Lordship may say
Correct
proposed.
it by pointing out that though tabled and referred to the committee, it was not
Formally,
introduced as
It was
bracket
subsequently withdrawn.
process.
and then subsequently
Subsequently
withdrawn.
withdrawn, not, it was it called the
The
first.
first bill was withdrawn.
Yeah.
Yes, it was called the.
However, the other Solicitor General would point out that Parliament is mulling, bringing in a new law which should address the concerns of the parties. It is his definite stand that the policy of the government of India is that the users of WhatsApp and other platforms in India should not suffer discrimination in comparison to the users of these platforms anywhere else in the world.
Lordship may not say
Did
that
not say
because.
that, Manoj.
We are saying it because we are not putting it into
that's
the
right.
We are
No, no,
putting it
yes.
into-
Yes, please.
Facts.
No, I'm not, that is my.
No, please record it.
No, Lordship.
Record it because that is his stand. That's why you are not going to be affected.
But why say WhatsApp, Malad? Just say all the users, Malad.
Media.
So then
all
you're also saying that
intermediaries.
WhatsApp, you know,
All
why?
intermediary.
All interviews.
Yes, so otherwise,
I
Malad,
don't say what.
it has also.
All intermediary. All intermediary.
As far as European Union are concerned, 27 countries
Don't
have a
worry,
different
that-
platform.
Don't worry, nothing is going to happen.
Out of 213 nations, only
You can
27.
continue to do merrily what you're doing. Nobody is stopping you in the meantime. Okay. Sri Shyam Diwan had a senior counsel for, you are appearing for the petition.
Yes.
So the petitioner would submit that, while it may be all right, if some time is granted for the Union of India in its decision to introduce a law and make a law, the matter being adjourned, it should be on the understanding that when it is listed on the next occasion, it will be taken up a final hearing unless it be the impact of the legislation overwhelms the issues which are covers every issue which falls for consideration in this case. But we are inclined to adjourn this matter, taking note of the submission made by the Learned Solicitor General to the 17th of January. This is case on the 17th of January for final hearing. By the 15th of December 2022, pleadings in all these cases shall be completed.
My lord's family request, we have an IA 11372, which is impugning the current 2021 policy direction. My lord, we should notice on that so that the pleadings can get
Not
completed.
WhatsApp centric. I don't know why.
But I
you-
think, but this is again,
Allowed
all these issues you can argue.
No,
Intervention,
intervention is allowed.
Allowed.
This is a application for directions, my lord. Just
To what direction for what?
my lord, which is on the 2021
It's against
policy.
It's
WhatsApp.
only against WhatsApp. It's only against WhatsApp's new privacy.
That's right.
policy.
What do you want? You want
There's
them
notice to be issued.
Not
my
by
lord.
virtue of an application, they want to challenge the new policy. Not,
I don't understand.
My lords will see the last order. My lords will see the last order of 15th February 2021, my lord.
doing that.
why not by virtue of an SLP, the new policy has been challenged in SLP. I mean, that only can't be done.
So, I mean, what is going to be the effect
legal
of
issue
not
to be
passing that order?
Okay, my lord.
It's going to be a legal issue finally.
That's right.
It's not going to go on facts as such.
That's right.
And there we will have the assistance of Sham.
Pleadings would not be of much relevance.
No, wherever pleadings have to be completed.
We'll have to be, but-
We are giving you ample time. But on that day, if it is not there, I mean.
Yes.
Nothing concrete doesn't have to be proceed to the hearing.
Yes.
You understand? So and so, just take the name.
Mr. Kanu Agarwal and Mr. Prabhas Bajaj will provide that
Will
convenience.
provide that common convenience volume containing
Documents relied upon by
documents relied upon-
respective parties.
The documents relied upon and also the contentions of all the parties.
No, but that's documents, no, that's just compilation will be documents and then,
It's only the document.
yeah, only the documents.
Only the document. All right. Only the document.
Common compilation of documents
Common
on
compilation of documents.
or before 10th of January.
But let's kindly add the name of Shashank Mishra from our side on the
Yes, certainly.
convenience
That's
compilation.
fine.
Yes.
So we're three of us, Malad. Just not Kanu Agarwal, but Shashank Mishra as well as Vrindavan.
You can begin by completely owning up the financial aspect of it. So,
No problem at all. Malad.
so we'll put together.
Shashank Mishra.
Common compilation containing all the documents relied upon by all the parties before the 10th of January 2023. Okay?
Yeah.
That's
Deeply obliged.
And if you would like a short note of submissions on or before 10th of January by the respective party. If you would like a written note, not necessarily we'll.
not necessary.
That's in both
Grateful,
cases,
thank you.
the corrected matter. Corrected matter also.
Looking at the face of the lawyers, I got a bit confused. Who is the face of amongst Dr. Sibal, Yogi?
Malad, all of us
Who is the
together.
face of Facebook?
No, all of us together. All of us together.
But,
We have our leader in Mr. Sybil, but we are all there to assist your lordship.
Lordship not taking like a Ravan with 10
You are not replying to Jared's question. Who is the face amongst all?
Grateful.
Yes.
It's a very
important but very simple, short issue. This is. That is the appointment of the election commission. Today, my lord, it's only the Prime Minister who decides. We are saying that in accordance with the reports of at least 4 commissions and committees appointed by the government, the selection should not be just with the government because it's supposed to be a neutral body, and the selection should be by a committee. Our suggestion and the suggestion of several committees has been that same kind of committee which selects the chief of CBI, that is the Prime Minister, leader of opposition, and the Chief Justice, they should together recommend the selection of the election commissioner. And on this, my lord, as I said, there are a large number of reports of several commissions which have recommended this or something similar. And the constitution merely says that selection will be by the president till such time, appointment will be by the president till such time that a law is made in this behalf. Dr. Ambedkar in his constituent...
Let's not argue, but this needs hearing. Let's really fix the
I'm
date.
just pointing out what the issue is. He had said that it would not be fair or proper to leave the selection only to the government. But thereafter, my lord, they felt that the law will soon be made to provide for a neutral selection committee. But unfortunately, it suits every government which has come thereafter to continue with the same system and leave it only to the government. So we are just seeking that direction in accordance with the directions that were given in Vinit Narayan, Prakash Singh, etc. That till such time that a law is made, let the selection be by this kind of neutral committee. That's the suggestion. So it won't take much time. I will not take more.
There's a second petition which has 3 supplementary issues which are raised. One regarding the protection that is given to the election commissioners apart from the CAC. That's one aspect. Second is having a devoted secretariat for the election commission. And the third is about its draw being on the consolidated fund. Now, all of these issues are essentially both Mr. Bhushan's petition and...
There are two petitions.
Yes, there are 2 petitions, 502 and 502.
I must inform your lordship that there is also a third petition which was filed recently. And Justice Rastogi had issued notice in that. Similar issue, same issue. Except there we are also seeking an interim order. So your lordship did not connect it with this one. And your lordship has issued notice and fixed it. It should be coming up soon after notice. But this matter will decide the fate of all the other matters so far as this legal issue is concerned. It's not a very long issue.
We'll list it on 9th of November. That's not.
Yes. That would be fine.
That's all that we have to do.
Yes.
Lord, only one thing, Lord.
Readings are complete.
I'm Lord, slightly on a different point. I can't have any objection, Lord. But 9th of November, my lord, there is already one constitution bench concerning, my lord, that the Delhi government will be the controlling authority for the civil services also, my lord. November and December being, my lord, very few days left, my lord. There are already 3 or 4 constitution benches fixed, my lord, because Court 4 is also taking up, my lord, matters of the constitution bench.
So
Court 3 or
has many law officers.
No, I'm
good law officers. So
he has to be nasty, but I ignore him always. This time also. Lord, therefore, my lord, kindly fix a date, my lord. My learned friend, Mr. Balbir Singh, is here. My lord, but we are also appearing there. So,
But let it not be put off too long.
yes, my lord.
it's very urgent.
Perhaps I just need to accommodate you till the 15th of November. That week, because this also has to go on.
Yes, certainly, my lord, certainly.
We'll put it on the 15th of November.
Very good. Very good.
Don't worry, I mean, that's
My lord, 15th of
15th or 16th, either.
my lord, 15th of November is, my lord, again, but both of us are there, my lord, in that article section 319, Sukhbir Singh Khera. But this is genuine difficulty, my lord.
We have no aid, but then we have to also go on with the
Yes, certainly.
allotted to us. So we can't be,
No, I am not, my lord, for a second.
In fact, the Attorney General has been directed to assist in this matter.
So that there may not be a problem for you.
Thank you, Gopal. I read the orders.
Sorry, I'm just saying
No, you
his
should be
convenience.
sorry for what you said,
No, I'm
but
saying his
but
convenience.
any date, my lord, other than 15. That's all.
So 16, there's no difficulty. 16th of November, this is case of the 16th of
Lord,
November for hearing.
Lord, 15th would
16th of November.
can I request? Only a minute. Only a minute.
Can I just say one thing? I'm just saying because a specific direction for the AG to assist, his convenience may be sought. That's all I'm saying.
The
Not
AG
trying to undermine anything.
That's
Just saying. Because he's not represented here.
The learned.
You're projecting your convenience.
No, I'm not projecting.
Lord, my learned.
Both of you are projecting. We are saying that we have taken a call. I think
Absolutely.
that decision
Absolutely.
should be left to-
Obviously, my lord, that's ultimate.
Let me make this.
I must tell Mr. Gopal Shankar Narayan,
Seeking
the learned-
in the least.
learned
Any date
AG,
your lordships choose,
Eh,
fine with me.
learned AG has assigned Mr. Balbir Singh and
Give a common compilation.
That will.
Lord,
Yeah,
instead
common
of
compilation.
my lord,
you make a-
instead
you
of
make it-
16.
You will make a compilation.
Lord, can I request for a day's accommodation?
Yes,
Lord,
sir.
instead of 60.
Huh?
Lord, the CB Court 4 is on 15th. Lord, it might spill over. Would your lordships consider 70
I mean, that's all.
instead of 70?
I'm fine
That's
with
not a problem.
any date. Whatever.
I am not
17th.
going to take more than 1 hour to argue this.
That's
matter.
right.
It's a very crisp,
So
clean.
17th of November, that is it.
Please.
Correct. Who will make a common?
Mr. Upadhyay will make it. Mr. Upadhyay. Mr. Ashwini Upadhyay will make it.
He's appearing in this as a.
He is 50.
Hello, Mr. Shyam Gopal, my learned friend, Mr.
Let
Balbir
me
Singh.
make it, let me make it, I'll make it.
Yes.
I'll make it. It's all right.
But
Shyam Bhushan.
Lord, everyone will have to coordinate with his office. My lord, his office is busy. Mr. Colleague of Mr. Balbir Singh, Mr. Shyam Gopal,
No,
and Mr. Ashwini Upadhyay may do.
that's, whoever wants to make it, I thought that.
I'm happy with anybody making it. I'm just saying, I am happy to do it myself, but otherwise, let whoever wants to make it, let them make it. I'll give them, in my case,
That's
the
right.
document is there.
Kindly fix the person who will make the common.
Mr. Shyam Gopal and Mr. Ashwini Upadhyay.
Let a young person do it. That's the.
Yeah.
Lord, all of us qualify, my lord, to be in that category.
Gopal and Gopal, Shankar Narayan. Somebody from your office, you can.
I'll do that. I'll have that.
Will put together a common convenience volume containing all the documents which both sides will be relying on before on or by the 1st of November. Your
Yes.
ample time, 1 whole month is there,
That's
Very
fine, that's fine.
That's fine.
so that we'll have the opportunity. Yes.
Grateful.
I'm appearing for the petitioners in one of the cases. There's a match of cases.
Accommodating all the.
Yes.
But the,
The Jallikattu.
Now, not here because of Tamil Nadu, Maharashtra and Karnataka, because of three sets of laws.
How does it come before the constitution? then?
There's an order passed by the specific, the past, kindly just see.
So
Second
broadly,
February.
broadly, how are the lines drawn? I mean, who's on which side, what?
Well,
We on the petitioner side, we say that the amendments pursuant to Jallikat are unconstitutional. They are saying they're valid. That's the only
That is
issue.
by the Tamil Nadu.
both,
That's
both legislative,
I'm appealing for
legislative
Tamil Nadu.
competence and
As well as-
fundamental right.
Both.
And of course, contrary to this court's judgments and today.
State of Tamil Nadu. right?
Yes, I'm appealing for the state.
Union is not, union is not.
Union, my lord,
Union is
my
not.
lord, I am appearing for the state of Maharashtra. My lord, I am briefed by the Maharashtra.
But may I just say this? There are.
But if Union is a party, some of us will appeal.
Here also the pleadings are complete.
No, there's one thing which will have to be done. There are specific questions framed on 2nd of February 2008, if my lord draws and has a look at the order.
Yeah.
The lordship will find this order relates to reference systems. That is relatable to the Tamil Nadu legislation. So now there are subsequent petitions filed. Those questions will just need that extent of modification in relation to the other legislation. Does your lordship have it?
Yes, we have it.
My Lord says,
It's the Tamil Nadu Amendment Act. If we get with that.
if my Lord is kind enough to see para 3 after hearing the petitioners and respondents for some time, we are of the view that the writ petitions need to be authoritatively decided by a constitution bench of 5 learned judges, as the writ petitions involve substantial questions relating to the interpretation of the constitution. The questions which require reference to a bench of 5 learned judges, apart from other questions raised, are set out below. Is the Tamil Nadu Amendment Act referable in fifth and substance to entry 17 basically of the 7th schedule, or does it further and perpetuate cruelty to animals? Can it therefore be said to be a measure of prevention of cruelty to animals? Is it colorable legislation which does not relate to any entry in the state list or entry 17 of concurrent list? The Tamil Nadu Amendment Act states that it is to preserve the cultural heritage of the state of Tamil Nadu. Can the impugned Tamil Nadu Amendment Act be said to be part of the cultural heritage of the people of state of Tamil Nadu so as to receive the protection of Article 29 of the Constitution? Is the Tamil Nadu Amendment Act in fifth and substance to ensure the survival and well-being of native breed folks? Is the Act in fifth and substance relatable to Article 48 of the Constitution? Does the Tamil Nadu Act go contrary to Article 51A(c) and 51A(h), and could it be said therefore to be unreasonable and violative of 14 and 21 of the Constitution? Is the impugned Tamil Nadu Act directly contrary to the judgment in Nagaraj and the review judgment dated 16 November 2016 in the aforesaid case, and whether defects pointed out in the aforesaid judgment could be overcome by the Tamil Nadu legislature by enacting the impugned Tamil Nadu Act? There is not similarly a Karnataka legislation of 20th February 2018, which is the sport of Kambala.
Yes.
Now, Lord, that has been impugned in, amongst others, WP Civil number 1152 of 2018.
So what are the issues we are?
That will apply.
Yes. So we just give a date.
Yes, I just want to mention, Manoj, that the Tamil Nadu legislation was referred to the president for the assent, whether that the Union of India, the president gave assent. I just wanted to mention that.
304B.
On our side, I think if your lordship is
Yes, thank you.
the
The
date will
president
be ready
assented
by
to
the
the
9th
particular
November, that
legislation.
was mentioned, 9th November, if it is convenient to the court.
That may be a little.
That could be a date which your
We
lordship.
should have it in after the other matter, the WhatsApp matter.
After WhatsApp, man.
Yes,
Wait.
because after 17th November, Manoj, the holidays will be there.
But if your lordship sees the calendar,
Calendar, Manoj, there are so many other matters.
Matter is in
January.
Have it.
because of the submission made by the.
Yes, your lordship may have it early January then, Manoj, whatever.
Why not November?
Yes, yes,
No,
9th November.
No, January already the thing will be too late.
Yes,
They will start Jallikat.
Absolutely. Either way.
You have to have it in November.
Whatever, Manoj, I have no objection to the date.
November may be better.
I would.
also requested earlier, just few minutes back, 9th November is the CP.
That's right. We have fixed that, factored that in. That's why we put it on that.
And after 17th November, any
We
date.
can put it on the 22nd or 23rd.
Yes, 22nd November.
That's much.
That will be, as
But it's a matter of housekeeping.
You are appearing for?
Not for the petitioners in their petition number 1193 of 2017.
What will be your contention?
That, my lord, that the act in question is is unconstitutional.
On legislative competency.
Legislative competence as the assent to the president, which is alleged to have been obtained, that has also been notwithstanding that the act is liable to be declared as unconstitutional.
You consider Article 30 petition?
Yes, yes.
Yes, all these are Article 30 petition as I see. There's an earlier judgment.
Petition, you go into question the legislative competence.
You can, my lord, provided there is also a question of violation of part.
Exactly.
Otherwise,
That is so.
not in Article 32. If it questions only the legislative competence, your lordships have said that it cannot be entertained.
Cannot be entertained.
But when there is a violation of part 3.
You're doing both.
Yes.
Yes.
All right.
I just want to
Readings are complete.
That's one thing I want
your lordships like. Sorry, your lordship.
How many items are there?
I think there are 5%.
May suggest one thing. If your lordships just have the calendar, instead of last week of November, if it can be first week of December.
That's too late.
That'll be too late, but then we'll have.
We hardly have
Yes.
2 weeks.
2 weeks. Yes.
Hardly have 2 weeks up in that.
Not in any case.
December.
Last week will be miscellaneous week, so in any case.
Precariously close to the closing.
And it will take, we will definitely be taking a while. We'll take a few sessions to present our case.
22nd November, I think we'll.
So in this matter, you can give your, there's some kind of a written note as well.
All right.
Yes, we'll have them ready.
Would your lordships kindly,
Idea, you get the slice.
Yes,
Yes.
yes. Broadly, they are crystallized, my lord, but
There are 5 petitions we
I
can.
think there
no,
are
15.
What is that?
1-5.
Okay, they are filed by.
Not all animal rights groups. Animal rights groups.
Different groups, Lord. What we
All
do-
over the country.
May I make a suggestion? We'll
You are
categorize.
appearing for?
Lord, I'm appearing, Lord, in 503.5, 503.6 and 503.12. So, Lord, I'm appearing for Compassion Unlimited and Peter, Lord, in two matters. What we will do for your Lordship is help on me. We'll categorize them as to which relate to which legislation, put them in
So
order.
who will do that?
Lord, I'll
No,
ask
the
my-
housekeeping
I'm happy
part
to
of
do
it,
the
my lord,
housekeeping.
Miss Mauleki, who has been
Lord, you can do
associated
this,
with
Lord,
this.
you can-
And Mr. Dharmadhikari Manoj can be.
Not a lawyer.
Siddharth Dharmadhikari.
I am saying that the writ petition filed by her,
I'll ask my.
we'll ask them to do it because they have been associated
So
with
that,
it.
in one volume, you get
Yes.
everything.
We'll have a convenience
With
compilation.
continuation of physics.
This Preeta Iyer is there.
Yes, I'm only saying that in the writ petition filed. Yes,
And the common readings are all complete.
Pleadings are complete except, but your lordship may just give, say, 2 weeks from today. A
Anything
week
that
from
has to
today to complete. There is a new.
All right. List is.
No, I'm sorry,
Just on the 23rd of November,
23rd.
for final hearing, number 1. Within a period of 2 weeks from today, the pleadings shall be made complete in all the matters.
Wednesday you want it?
2. A common convenience compilation shall be prepared, cooperating with reference to all the 15 repetitions
writ petition.
by
Miss Preeta is.
By Miss.
Yes, Iyer.
Miss Preeta is.
By Miss
Preeta
Preeta
Iyer.
Iyer. Lord, we'll give the name.
And my lord, Mr. Dharmadhikari on our side. My lord. Siddharth Dharmadhikari.
And Mr. Kumana.
The
Mr. Kumana.
Rural Welfare Board, which is the main statutory authority, they would want to do it, is it?
Milord will be doing it.
Let them do it. They are the neutral.
No,
party.
but that's right. But let's be so there's nothing.
All are neutral. For compilation, there is.
what
In a
difference?
compilation, what?
That's a debate. We have already.
You do it together with them.
If it was a vegetarian, it will be a neutral party.
Lord, in fact,
They are a
in
statutory
fact, Lord,
authority.
on the lighter side, they don't take it otherwise. They are all meat-eating animal welfare groups.
Meat eating, I'm sorry.
Except Mr. Diwan, except Mr.
No, no, I thought fish was not meat.
No, I'm sorry, I-
Sorry, fish is not meat. Please don't mistake fish.
So on the lighter side, my lord,
Maybe so, but.
No,
in
no,
a
but
matter like
I
this,
contest.
the sensitive comment.
That's all right.
that's on the lighter side.
So now, individual submissions, we'll have to make.
We will make a week before that.
That cannot be, a combination.
No, that'll be separate.
We'll make it 2 weeks.
Lordship may say.
The petitioners will make available their written notes not exceeding 5 pages,
Yes.
containing a gist of the issues, the contentions and contentions, and the case law, which they rely on.
Yes.
On or before the 7th of November.
Yes.
Much
That
obliged.
will be, we get ample time.
Yes, of course.
Well, that's 14th would be better because your lordship said 22nd is the 22nd is the
23rd,
14th.
Because if you get it before,
Well, 1 week before Malaj, your lordship.
why? Because you've got a month already.
Your lordships have to read 60 briefs every day.
That's right, that's right. We have to do it all of it.
Towards that direction.
We are very thankful.
Pleadings.
Yes,
pleadings.
our brief.
We have already said that. We
Very
will-
good, very great, very great, very good.
Coordinate with everybody.
Obliged.
2 weeks, put it in 3 weeks, because of our coming.
Holidays or so. It's 3 weeks can be.
Yes,
Make
3
it
weeks.
3 weeks in place of 2 weeks for completing the readings.
Grateful.
Fine, fine.
Nice.
Grateful, Lord.
504. What is 504?
I appear 504. So this is a matter which was first filed in 2005 as a writ petition. And this is what was popularly called living will or
Euthanasia.
not euthanasia. Euthanasia is assisted dying.
That's right.
But this is an advanced directive. But this is not euthanasia. Euthanasia was that Shanbag, Anuradha Shanbag, where she was lying comatose for 28 years and finally in one.
From the assisted died.
No, this is not as. But I'll explain what it's an interesting point. But all of us have to ultimately meet our maker. Now, to give an example using the singular pronoun, I can today, but this is a matter regarding advanced directive or what is called living will. But before Lordship sees that, I'll just give a broad outline of what this is. Today, I can make a declaration stating that if I happen to be in a coma or if I'm not in a chance of recovery or I'm brain dead, etc., then please don't have any intervention, no life support system. I'd like to die with dignity rather than suffer the eating of so many things. Also, the family is put to the avoiding embarrassment of spending huge amounts, etc. So I do it. So this is a concept accepted in different parts of the country. So finally, we placed this matter before the court. And what happened was the court issued directions, which ultimately turned out to be unworkable because after the directions, we spoke to a number of doctors. Now, basically, what the Constitution Bench has said is this. Suppose tomorrow I sign an advance directive. So today, let's say on the Dasara holidays, I have to go before a judicial magistrate first class. I must say, I, Arvind Datar, etc., make a declaration that in the event of my, sorry,
Don't use your.
I XYZ, sorry. My apologies. I XYZ make a declaration. I have to make it before the judicial magistrate first class that don't have any life support system. Now the XYZ's time ultimately comes maybe 10 years later, 11 years later. That time, what the court says is, suppose he's admitted, let's say, in Apollo Hospital, Chennai. Then a team of doctors in Apollo Hospital must certify that there is no hope of recovery. This person is brain dead or he's not able to live. That's first stage one. Now, then the matter is referred to the collector. Then the collector has to constitute another board of independent doctors who will take a second opinion. After the second opinion, it has to again go to a judicial magistrate first class who has to personally come to the hospital where Mr. XYZ is and certify that it can be withdrawn. But we took these directions. I personally discussed the matter with 2-3 leading doctors from Chennai, and I also spoke to 2 doctors from Bombay. They said this is unworkable. You can't have a system. Suppose a person, let's say, is in Apollo Hospital. He's an 85-year-old man. He has signed a living will that his life support system should be taken away. Now, you can't expect Apollo to constitute a committee. They can. But then that matter has to refer to the collector of Chennai. The collector of Chennai then constitutes this independent medical board. That medical board has a second opinion. That is then again taken to the judicial magistrate. He must come to Apollo Hospital, see Mr. XYZ and say he's now life support can be withdrawn. So what we have done is, each of the directions issued by the Honorable Supreme Court, on the basis of discussion with doctors, we have suggested how it should be amended. That's the thing. But in fact, what happened was the court said that.
So who are the respondents in your case?
Union of India.
Only.
But they filed a counter saying that these suggestions are not suitable.
Right.
I thought that they.
Next of kin has that choice. Unfortunate choice.
Very difficult choice.
Very difficult.
Very difficult choice.
It's available with the next of kin. And any person can refuse treatment. As of now, as the law stands now.
But this basically
If somebody is very unwell and he chooses not to go to hospital or to any doctor, no one can compel him or her to go. That is the law. What stands now.
There's a
You
practice.
are talking about a situation where he is under treatment, but medically there is no possibility of his going back to normal life or going back to life,
Lord, one suggestion, he is in a state where he is incapable of taking a decision.
incapable of taking
Yeah.
a decision.
Rather,
Right now, the family members take.
Yes, yes.
So you want him to take that decision in advance.
So XYZ today says, so let's say XYZ is, let's say 70 years old. Now he's going to make a will. He's going to make a will bequeathing his property. He also makes a declaration there that in the event of my coming to a situation where I have to be put on life support system, the Lordship is right. We are all relatives who say, please don't do all this. I would like to go peacefully. I don't want too many surgeries, etc. So I can make a statement before the judicial magistrate first class that we are willing to accept. If they want a safeguard, we can have it. But this multiple committees of doctors, reference to collector.
One committee. Can't be a one committee.
One committee.
Doctors examine it, then the magistrate and all.
The collector.
Can't one committee at the one go take a decision? And if suppose he is not capable in taking it so, can't be the first kin to that person.
But excellent. One committee of doctors plus the kin can also.
Yes, one committee.
No, this is I have not.
You can't keep the line pending for long because you don't know at what point of time he might collapse. So he has to take a decision at the first go. One committee.
At the earliest.
The earliest. One committee constituting all magistrates, independence of the committee, and the government also keep a check over it. And the first kin to that person.
Son, daughter, whatever. Yeah.
One kin, whatever. The magistrate takes a decision.
The magistrate will be difficult because let's say a place like
whatever it possible.
a judicial magistrate first class. Now let's say Delhi or it's Madras. Where is it? Egmore? Is it this or Bombay? So is it Powai or is it Andheri or is it Bandra? Who knows? It's very difficult.
In the judgment dated 9/3/2018, A to E, 5 directions have been given. All directions are there in that judgment.
Yes, which I have tabulated.
That is in page number 13.
Yes. So we just wanted to see if Lordship is willing
This is actually an application
to modify the
matter, to modify.
Yes. Yes.
Usual application, but now it has made its way to the constitution bench. Because
No,
it was
because
decided by the
constitution bench. No, the only thing is, having speaking to the doctors, as my Lord Justice Rastogi suggested, why have multiple committees? But let it not be that person's. Let somebody responsible take a decision.
What is the stand of the government?
I have not my Lord, had the benefit of going through the affidavit, but forget the affidavit. This is a human problem, my Lord. And my Lord, people do face such problem, and we also know, my Lord, all of us, many people who would say that if I meet this kind of a fate where I am almost going, don't insert things in my body, etc., etc. So, my Lord, this needs examination. The only concern, my Lord, which is again my concern, I have not discussed with the government, but the concern was, my Lord, even during euthanasia, etc., that in our society there are circumstances where old people who are our elders and their blessing should continue forever for us, sometimes in some families become unwanted, and this may not be misused by the family member. So there has to be some cushion, my Lord, so that whatever he says is true. As a matter of fact, my Lord, I know of a very senior, eminent lawyer, my Lord, eminent advocate in Gujarat. He was detected with cancer. He said, I don't wish to be treated. We were like children to him. His contemporaries also went. We also went to persuade him. And his answer was, now it's his call. I don't want him to tell me that you have to be dragged. I want to tell him that I came gracefully the moment you called. I don't want to trouble my family. I don't want to trouble this body, because with treatment, maybe I live 3-4 years more, but I don't want to be dragged. So there are several reasons for it. A person would not like to subject himself to such agony and subject the family to agony. So I can sit with the government, and there's some way can be found. This
Also
cannot.
essentially domain of legislature.
Correct.
Possibly.
No, this is like a 142 Vishaka situation till the government makes a situation.
Till the legislation falls.
No, when I spoke to doctors in Bombay and Madras also, many families can be financially ruined because the person is in coma, ICU endlessly, nobody is taking a decision, then what happens?
But that family can take the decision.
The difficulty
when to pull out the ventilator, that rests.
No, this guideline doesn't say so.
My Lord, the harsh reality, I can tell you, Lordships. And again, my Lord, leaving the brief aside, as a human problem I'm seeing this. But I have seen cases where the doctors say that a day or two on ventilation will survive the person. But the ventilation charges are very high. And there was, my lord, a fight amongst brothers who will share them. And it was decided that better not to put him on a ventilator. And some of our, my lord, friends and group, my lord, we collected the money and the man survived. My lord, leaving it to the next of the kin might be counterproductive also. There has to be, my lord, some way out so that this is not misused. And the wish of the person not to be subjected to any undignified way of forced survival is, my lord, respect.
Forced survival and also forced departure.
Yes. Yeah, both will have to be balanced.
Yes.
But I know cases where people have.
23rd, because they have
Yes,
put
yes,
that other matter
yes.
on 23rd.
Yeah, they know.
So,
But this can be. But I'll in the meanwhile.
Tell the learned solicitor, Lord, there is an order passed on 22/1/2020. Unfortunately, it came just before COVID and everything got delayed.
What I'll do is, what I
there is a
suggest
joint
is,
meeting is undertaken to have a look at it.
what I'm suggesting is, not, forget the order.
Joint meeting. There's an order of the court.
Okay. I was suggesting that. I didn't know this.
Just to see that.
Otherwise, I'll call the officers. I'll invite
22
Mr. Datar also
Yes.
at my place. I'll call the officers also. We'll have a joint meeting. But maybe they have some concerns, some apprehensions which can be taken care of.
Better because you know,
Yes, yes.
hearing
This is not a
will should not be a matter. This is not adversary.
They cannot be adversary. It's
Cannot be adversary.
My friend is right. They could be a case of a misuse. But they could many cases where it would be great relief.
correct.
Great relief. The earlier case, Mr.
Earlier
Bhushan
case
said it'll
is-
get over faster. Let's begin.
That's right. We just put it on that day. For some reason that doesn't happen.
24th.
So
Mr. Bhushan's matter, your lordships have kept it on.
23rd. This will be after that.
23rd. So immediately
Immediately after Jallikattu.
Exactly. Whatever is listed on 23rd, this one 23rd. Just say nothing.
And Lord, I've just given the guidelines issued by the court. What is the problem after discussing with doctors, and what could be the modified? Lordship may just think of some safeguard. My Lord may also, your Lordship may come up with some new idea also. We don't know. Your Lordship also may come with some thoughts, because all of it is a problem which affects all of us.
And we have seen experiences on either way, as my learned friend is right, that benefits are more, misuse may be few and far between, but even one misuse would be a murder, virtually.
Yes, yes.
It would be.
Just for getting in the middle.
Mr. Datar,
Yes, sir.
I'm just reminded, you said ideas. There was a very interesting film, I should say, and the title of the film was "Whose Life Is It Anyway?"
Anyway, yes.
You might have seen it, that sculptor who was confined to bed. I think it would be an interesting film to see.
In the vacation.
You have not seen it in the context of the debate that we have. Whose life is it anyway?
And Lordship, there was a recent
No,
thing.
there was a-
There's a Switzerland has assisted. Lordship mentioned assisted dying. Switzerland has assisted dying.
Yes, yes.
So an Australian who was 103 years old. He went there and he said, "I want to hear my favorite music for the last time," and then they administer
Even
the.
the Jainas,
But we are not
that's the subject matter in this part, therefore I will not elaborate much. But Jains have, my lord, the system of Santhara. That is, my lord, the highest form of detachment from the body.
That is still something different.
That's something different, no, not comparable, my lord. And Bertrand Russell, my lord, apropos, my lords, there is a beautiful article written by him, Right to Commit Suicide. My lord, he also says, it's my life. How are you concerned with? If I don't like my watch, I might even as well throw it in the ocean. Why can't I do that with my life? That's the theme of his article. One may agree, one may not agree, but very well put.
In fact, an old judge of the Madras High Court said, this is one case where the offence is not punishable, but the attempt to commit the offence is
Offense is right. Yeah, that is right.
That's it. But the constitution has been upheld.
Yes. In fact, there was another question, full bench of Madras High Court.
Many of these cases of suicide can be really put down to mental health issues.
Yes, yeah, very true. Very
A lot
true.
of people die by suicide because they reach a stage where if they are properly counseled,
They could have
they could be protract.
There are some helplines now.
Yes, yes.
Where you can
Everywhere,
immediately dial the
everywhere.
number. Helplines are there. But Lordship is right. Young people,
Oh, yes.
mid-30s, 40s.
They know, and that again, my lord, maybe I may not find, my lord, much takers of this view. That's because of, my lord, the family shrinking.
Absolutely.
Because if I am in depression,
Yes.
my brother,
Nobody
my
can
father,
talk with-
Yes,
there is
yes.
somebody who will
That's
push
the
my.
system work very well.
Now a two-member, three-member family, there are no friends, only virtual friends. I have, for example, a person has 5,000 friends online,
WhatsApp friends.
WhatsApp friends. There is no his neighbor also to talk to. These are one of the issues.
Lord, in fact, let's just say in a lighter vein that HUF is only in the Income Tax Act now, my lord.
That's correct. Practically, it is only income.
It is.
All right.
Grateful.
My lord, your Lordship may say, the order says have a joint meeting. My friend can give a date immediately after Dasra holidays, my Lordship.
We the year for that we may not trouble the court. We'll coordinate.
I'm not putting it down.
You are always welcome. Anytime I'll call the officers on that day.
All right. So what is this? 505?
May I give a brief outline as to how the matter has travelled to the Lordship? So it's,
Arbitrator.
it's the question, my lords, whether an arbitration agreement in a contract which is required to be stamped and registered is not registered and stamped, whether that arbitration clause can survive. Now, my lords, the matter travels like this. My lords, we filed a suit. Work order was issued by respondent to me, unregistered document, unstamped document. In that, there was an arbitration clause. We filed a suit because it involved invocation of my bank guarantee. The trial court granted me ad interim injunction. They filed a Section 8 application. Relying on SMS T and Garwale, we said that this arbitration clause cannot work. Trial court rejected the application. Against that, a civil revision was filed, kept pending for 2 years, withdrawn, then a writ was filed. We objected that Section 8 order is appealable under Section 37. A writ is not maintainable. The High Court clause by the impugned order said it's not an absolute bar. In peculiar facts, we go by and we filed a review, dismissed. We came to your lordships, and our only argument was that Section 37 is a remedy. 1. 2. SMST and Garwale say that since your contract is unstamped, the arbitration clause is non-existent. It cannot be worked out. With utmost respect, the matter was closed for judgment in November. Vidya Dhrolia affirming Garwale and SMS came in December. And the judgment clause, which makes reference, is in January. It holds SMST overruled because Garwale is affirmed by Vidya Dhrolia. Therefore, Garwale is now referred to your lordships. That is how it is. We never argued all this.
January,
I have no difficulty.
Who is appealing against it?
Because there has been a subsequent development. The direction was to impound the contract and I was supposed to pay. Document impounded, I have paid. My bank guarantee has been encashed, 3.5 crores. And now I have invoked an arbitration clause saying that please give me back my money.
But who is appealing as respondent? Nobody.
It was contested on first minutes. They appeared.
If there is nobody, we may have to consider appointing an amicus. That's why if you don't do it today.
There was a caveat.
We were just appearing for the bank, was not concerned with the arbitration.
In fact, let's.
For that day, there is nobody appearing. Nobody is there. You're not contesting.
Looks, they were there in the first round.
There are two.
Was a caveat there.
Charu Ambani and Sanjay Kapoor.
That's right. There was somebody.
There was no, they filed a caveat. It was
they may
after.
have filed a caveat. Now,
After recovery, because they've got the money. So perhaps.
leave granted. Here it concluded judgment reserved.
That is 23rd November. And Vidya Dhrolia came on the 14th of December. And we never had any opportunity of making any suggestions on Vidya Zolia.
I did not brought this actual notice of the court that some judgments are pronounced by the after the judgment are reserved in this case.
Milords,
Would I make an application to just
with utmost respect, I tried to file a review application. It was not accepted in the registry. Number one.
Not
Number
review.
two. No, Milords. Then I filed an application for modification of the judgment, modification of the order. Not our case.
Having regard to the nature of the issues which fall for our constitution in this matter. And saying also there is none appearing today for the contesting response.
Respondent one.
We have considered that the amicus must be appointed to assist the court. Facts of this case, we appoint Sri Gaurav Banerjee.
I will supply.
Senior counsel.
Which I will
He is a senior.
Senior counsel. To assist the court in this matter. The registry will forward the papers to the amicus. And this is case 15th of what day is that we put at imagine that 17th January.
Milords, may I have one request? There's an IA which I have.
How long will you take? Must tell us how, depending on how long it takes for you to convince us.
Because according to me, the whole judgment is premised on things that we never argued. Neither of us argued.
No, but once the matter has come to us, we have to examine and decide the issue.
We will.
One for all.
I'll take not more than half an hour, Milords, because my IA contains all the material, the relevant provisions of the Maharashtra.
Judgments are there.
Everything. Only a compilation perhaps of judgments that I'll take.
As regards registered, unregistered documents also, this principle of impounding, there are two lines of authorities. One is that court cannot look at it.
That's
The
what
other view is that,
impound and then pay
Impound
duty and then
well, yes.
this direction was issued. Our document was
Anyway,
impounded.
so there are two line of authorities in those for immovable property also.
Was never argued. Nothing of this was argued.
I think single half day is sufficient.
More than sufficient. More than sufficient. More than sufficient.
We put it on the 6th of December.
6th December. May I have just one more request? There's an IA which is IA number 24652 of 21, which was for modification, but ultimately it was said that this is akin to a review, dismissed. It has all the material. That IA may be taken up and permission.
Make it a part of a compilation.
I will do that. I will do that. So, Milords, 2 weeks to file the compilation.
Petitioner is granted 2 weeks available to the board a compilation. Containing
the contents of IA number 24652 of 21
yes,
and all relevant judgments of your lordship.
containing this also and the issues involved.
The issue is only.
You can just put a note because
The issue is, the question is crystallized already by the court referring the order.
all the details and containing all the details.
Yes.
So the compilation containing the contents of IA number
24652 of 21 and plus the compilation of judgments.
and all the
Relevant judgments.
relevant details.
Give us name of three lawyers who are very active in arbitration, young lawyers.
Mr. Data.
No,
Mr.
not Data.
Mr. Balbir Singh.
We want three young lawyers Not Balbir Singh is not young lawyer. He wants 3 young lawyers into who are into very active in arbitration. Mr. Banerjee, who are those young lawyers, according to you, who are very active in arbitration?
Oh, there are quite a few.
You can't select even just now. Give the name.
And he's saying he will select the name.
I'll get hold of it.
Not for your assistance, for our assistance.
My lord,
We want our assistance. That lawyer.
there are quite a few of them, my lord.
This is also there.
Give us names.
I'll give a few names.
6 December.
6 is.
Very well.
Where is it?
My delegate.
Now, this has some importance for the armed forces. What has happened is, my lord, there was an application for clarification which was filed on behalf of the Union of India, pursuant to, my lord, the judgment in Joseph Shine. Joseph Shine, as your lordships know, strikes down adultery. And broadly, my lords, the grounds were that this was essentially the patriarchal aspect of that provision, which treated women as chattel. Now, my lord, be that as it may, we're not directly concerned with Joseph Shine because that was decided on a different. My lord, we are really concerned with what amounts to discipline or indiscipline in the army or the armed forces generally, and what is unbecoming conduct. Because we have our own, my lord, the armed forces would have their own code of conduct. And therefore, my lords, if what has happened, let me just indicate as to what has occasioned this.
Finding it in the form of a clarification.
My lord, what happened was this was a clarification because what happened was this, my lords. There were officers who were charged for unbecoming conduct on the ground that while my lords, that they were having illicit
Feeling the
relationship.
affection or something. The expression used is.
My lord, illicit relationship, my lord, you may call it an extramarital affair or whatever, my lord,
There's a-
unbecoming conduct. We call it unbecoming conduct or, my lord, indiscipline. So what amounts to that? Now, when, my lord, an officer is serving out there in the field and his family is stationed in the, my lord, family accommodation away from the field, and another officer, my lord, enters into, it may be consensual in nature, but therefore, my lord, can we not take action? What has happened is that the AFT took a view in some cases that it must be quashed because of Joseph Shine. So, my lords, this would certainly create some instability within our ranks because, my lords, ultimately we have to be able to, my lord, inspire confidence in the officer who goes to serve in the field. And, my lord,
You're saying that they can be charged for misconduct.
Misconduct, indiscipline, unbecoming conduct, and, my lords, because adultery has very different patriarchal, my lord, connotations under 497. Now, here under this, my lords, our action we can even take against a female officer. There is nothing unequal or it's completely gender neutral. But so this is the issue, my lords, and therefore, my lords, this has been put before a
So
constitution.
which part of the judgment
Yes.
of Joseph Shine's actually creates a problem for you?
My lord, simply because what has happened
What is it that you're seeking to
My
clarify?
lord, we are seeking to clarify that the Joseph Shine judgment striking down section 497 will not come in the way of the armed forces taking action for under certain provisions, my lord, under our respective acts, including the Army Act.
Does it preclude you from doing it? Does the
My lord,
judgment
what has
foresee-
happened is the AFT has taken such a view.
But then should you not independently challenge that? I mean, instead of
No, we have
clarification.
We have challenged it, but my lords, it requires some because my lord, they are using the Constitution bench judgment in Joseph Shine.
Say the Constitution bench is either right or wrong.
Right.
If it is wrong, you have a remedy of review.
No, my lord, we are not saying it is wrong because it said nothing in respect of the army.
That's right, exactly. Therefore, if you say it is wrong in individual cases, if you have challenged it,
We have.
you have challenged it.
We have,
So
my lord,
there-
and the question has been left open. What has happened in one of those judgments, we have
You
it.
can always pursue that, saying that Joseph Shine cannot stand in the way of your, taking action against somebody who's.
My lord, this has specifically been referred to a Constitution bench.
It is said the criminality about adultery
Right, right,
has been done away with.
right, right.
So that doesn't mean that
Service
the
of
conduct is that does not mean that the conduct cannot be treated as misconduct.
Absolutely, which is
By
what
an
we are
employer.
saying. Correct, correct.
Is there any taboo against that?
Because under section 63 and section 45, you are referring to
Absolutely.
those.
We are relying on that. In fact, we had charged one of these officers under 45 and the AFT took a view and this is coming up in multiple cases. Yes.
Any kind of a misconduct defined
Yes.
has to be examined independently.
That's exactly what we are saying, my lord.
How this judgment will come in your way in taking a
Lord,
decision?
this is what unfortunately the AFT has been doing.
That you can challenge.
Lord, we have challenged. In one of those decisions, my lord, the court, this court,
Yes, relying on this, this was your.
my lord, because my lord, there he had been acquitted, so that was taken care of. But as far as the question on section 63 is concerned, my lord, the issue was left open. So, my lords, what has happened is that this has been referred to your lordships because Joseph Shine is a constitution bench judgment. So, 3-judge bench has referred to. So, my lord may just decide the issue whenever convenient. It won't take very long.
Just 1 minute.
Yes.
Immoral act. Any immoral
Lord,
act
we don't use a.
is not a criminality.
Yes.
May not be a criminality.
May I submit?
Exactly the issue, my lord. Should they be treated as a criminal or just a simple misconduct? That is the only issue, my lord.
May I submit?
Lordship has taken away the criminality part from the adultery provision, my lord.
That's correct.
But they are still treating them as a criminal, my lord. That is the only concern.
No,
That is the whole point. If it is a.
see, a man may not be, it might be slightly different to say that you should not be punished because the woman cannot be treated as a chattel.
Yes.
And dragged to the court and things like that. You know, in the uniformed services,
Yes.
where discipline is of the paramount importance,
Yes.
the aberrant conduct, at least as it is understood to be, conduct which involves actually shaking up the life of the officers, because everybody is ultimately dependent on family as a unit for society. And the integrity of the family is primarily based on the faithfulness that each spouse expects of the other. So if this is going to shake up, discipline, the life, the even tone of somebody's life, and the armed forces must have, some kind of, they should have some kind of assurance that they take action. How can you cite Joseph Shine and say that, it cannot be?
May I submit, Willis? I am appearing for.
It's not exactly desirable conduct. See, when you say that it should not be treated as criminality, and it's not a criminal offense, the court is actually, in this particular case, actually taken a value judgment of its own, substituted that for that the legislature with reference to fundamental rights and said it is violative of fundamental rights. Okay, that's fine.
Yes.
But the employer says, you take a case of a private employee, forget about the state. Supposing the private employer has its own view, he says that we will not permit this, and we treat this as misconduct. Treating it as an item of misconduct, action is taken. Can you produce Joseph Shane and say, no, you can't?
Not at all. Not at all.
If a private employer can be permitted to do that, then why not stay?
Willis, may I just make one?
I was appearing for Joseph Shine. Shall I make a very short submission, Lord, in answer to your Lordship's query?
Yeah.
I was for the petitioner in Joseph Shine.
We know that.
I am just making a very short answer to that. As your Lordships were observing, there is nothing for a clarification at any rate. What I am respectfully placing, Lord, as your Lordships were observing, including Joseph Shine, we only, Lord, challenged the constitutionality of 497 of the IPC and 198(2) of the Criminal Procedure Code. These three sections, or this half a dozen sections, were in the Army Act, in the Navy Act, and in the Air Force Act, were not the subject matter of Joseph Shine. So what essentially happens is, when it is something the respondent center cannot have a case which the petitioner in Joseph Shine did not have. We cannot now expand the scope of the repetition in a clarification application. That's what I am respectfully pointing out, Lord, as your Lordships were observing. Now, my Lord, as your Lordships were saying, if at all in a particular case, well, the a defense in the light of Joseph Shine was taken, but it is then for the center or for the authority to prosecute, to pursue that particular case. But one case, but in United States Court of Appeal, Perez versus State of Roseville, but was a case where a departmental action was taken for the alleged bad conduct. Then the United States Court of Appeal decided in Perez versus State of Roseville, one will have to find out the nexus between the alleged act and his official duty. Likewise, but in our country also, unless and until it is agitated in a particular given case, this cannot be decided now. But the Joseph Shine decided only 498, and the Lords may also appreciate one fact. Neither of these sections.
You take the case where there's an enumerated item entering into an illicit relationship with somebody else, and
Yes.
a live-in relationship with another man's wife,
Yes.
amounts to misconduct.
Yes.
Correct. Can you
Yes.
apply Joseph Shine and say,
No, it cannot be. That's what I am also saying. Joseph Shine did not decide that.
that's exactly what you're saying?
May I just make one submission?
Joseph Shine did not decide that. It is beyond the scope of Joseph Shine.
It is a simple
Can I
question.
just make one submission?
Yes, yes.
Section 45 and 63 of the Army Act are very clear. If at all any person subject to the Army, Navy or Air Force Act behaves in any manner which is unbecoming of his conduct as an Army officer or Navy officer, Air Force officer, he is likely to be, he is absolutely liable to be punished for misconduct under the 45 and 63. 63 says any officer or any member of the armed forces subject to this act, if at all behaves in a manner prejudicial to army discipline.
Probably this officer, additional officer, what people is concerned about.
My lords.
Some of the observations in Joseph Shine.
My lords.
It perhaps tends to sort of give the impression.
My lords.
That you will be intruding into the liberty and the freedom of the individual.
We will see.
It's a choice.
My lords.
But freedom appears to be to have an illicit relationship.
Very well.
You cannot go there.
Do that, my lords. Do that, my lords.
That cannot.
May I just say this, my lord?
One more
To
thing.
this, my lord. Yes.
Now, in this, suppose is for this sanction, of course, in the light of the decision, he cannot be penalized.
Yes, my lord.
But at the same time, the question is whether he can be subjected to disciplinary procedure. In terms of the
That's what, that is what we are trying to answer. As your Lordship Justice Ravi Kumar was observing, but what I would respectfully answer to that, Lord may kindly appreciate. But none of these sections,
He cannot be penalized under the provisions of the IPC.
That is different.
But certainly under the provisions of the Army Act, he can be penalized.
That goes without saying. That's what I am also saying. What I am
Madam, I would request you to just wait a minute, please. Just a minute. Lord, what we are saying is that because there is such a large number of cases which are coming up before the AFT has taken a view. Now, my lords, if we keep appealing in individual cases, which of course we have to do, in the meantime, my lord, there are so many disciplinary actions which are being stalled, and it is very dispiriting, my lords, for the officer who is serving in the field. So, to my lord, that kind of confidence we have to give our officers.
There, the solution is,
yes,
in one case,
yes,
the matter is decided in one of those cases where the party is also heard, and this court, if you are going to have a final decision, this court is
I think, my lord, we are requesting this court because it has already been reported.
Clarification.
My lord,
we think that.
my lords, for once and for all, it will take care of the problem. It won't take very long, and your lordships may have to go on.
In one of those matters where you are quoting an order again.
Right.
You can challenge it, right? That particular decision with the person also on the party array. So he will have to say, I don't know whether he's here in your clarification.
No, he's not
here. So we are invited to make a clarification in the absence of a person who is going to be affected.
No, my lord, may I put it this way? My lord, we can certainly implead those parties. No, I'm just suggesting this, my lords, because ultimately, my lords, it requires clarification, and this court.
How are you here? How are you here? You are here because there is an AFT order.
Right.
Which takes a view that the employee whom you are charged with misconduct is protected by Joseph Shine. We take it that's your problem.
Yes,
Still.
yes.
So that order can be independently challenged. Which is why we began by saying whether you say that Joseph Shine is in any way wrong. You say you have no quarrel with Joseph Shine. You say Joseph Shine is fine.
No, because that is the way we are reading Joseph Shine,
That's right,
which
exactly.
is, yes, that is the way we are reading Joseph
Once you
Shine.
accept that Joseph Shine is
Right.
right, this clarification business I think should not be sorted to.
Milord,
It's better that you carry the matter. You will have a final
please
discussion.
consider-
If the other person also on the party area, you will have a discussion.
Milord, just give me a minute. Let me just confirm.
That will be better.
Then can I just make one submission? Instead of tinkering with Joseph Shine, what my lord said is absolutely the correct way of going about it, because the person involved in one of my clients in fact has suffered 3 months rigorous imprisonment for allegedly having an extramarital affair with somebody else, some unmarried woman. However, my lord, it doesn't fall under the ingredients at all of Joseph Shine or adultery. But what happens is Joseph Shine by itself, my lords, has secured in dignity and equality to women, not making them subservient to the husband or his consent or on that footing. However, my lords, to say that what they are trying to make out probably is that culling out or classifying army wives, what their submission in the application is quite shocking. They say that army wives are living separately in in separated family quarters, and their husbands, the officers, are at the border. So the husband should not have insecurity in their minds that their families are dealing with undesirable actions. Well, this is an affront to any army wife. In fact, me being one.
No, it's not applicable to army wives. No.
Absolutely, and that the
I
context.
may also point out, I may also point out, Lord, more explicitly, but a review petition was filed.
Let her make the submission.
Well, because if my lords just reads the contents of this application, they are actually the prayer may be very.
Why do you say it's an affront to the?
Because they just read one paragraph, my lords.
You can tell us in your own words.
Yes, yes. What they say is to ensure that all personnel perform their duties without unnecessary concern for their families. There is a system where frequent visits to families living away from their spouses by officers, JCOs, is a regular feature. In view of the aforesaid judgment, there will be always a concern in the minds of the army personnel who are operating far away from their families under challenging conditions about the family indulging in untoward activity. Well, is this paragraph and also some.
See, it's only concerned with the army officer involved.
So,
if the concerned lady or a male
absolutely
is having a relationship with a person who is not an army personnel,
that's right, my lords.
that is not prohibited.
Absolutely. So what happens is, where do they draw the line? If an army wife.
An officer gives a complaint.
Yes, your question, please.
Wife of the officer gives a complaint that he's having an affair with somebody. Or you're talking about the adultery being committed by the wife, isn't it? Yes. Wife of the officer.
Not in this particular case, yes, that we are talking about, yes, we are talking with another officer. With another officer. In this case.
No, in the event the lady is the officer and
both it's gender neutral. Our action will be absolutely gender neutral in that sense. But my lords, I just want to say that please do consider, because your lordships are taking up these matters, because this may what has happened is, and that's why, my lord, the 3-judge bench referred it to the Constitution bench.
So what
because
is there anything in the judgment
Right.
which stands in the way of your, treating this
Right.
kind of conduct
Yes.
as misconduct. Is there anything in the judgment which precludes you from taking that?
My lord, because, my lord,
For example, supposing the judgment says in some part
yes.
that it's perfectly all right for a married woman to have an affair, perfectly all right, then it can't be misconduct.
My lord, very frankly, my lord, because our list came very, very late at night and I was informed in the morning, I have not had the chance to comb through Joseph Shine in such detail.
Unless you do that and point
yes,
that out.
yes.
Nothing is stated, my lord, in the clarification application either.
No, so my lord, what has happened is
One
that
point
each
I may
judge
make.
has advisedly, my lord, put this
Why don't you
before
then
five judges.
go through the judgment?
Yes, I'll go through it in more
If
detail.
there is anything
One point I may make. One point I may make. My lord, none of these sections.
There's no need to spend more time on it. Give a date, that's all.
Yes, I think fair enough. Fair enough.
And we have told you our view.
I've
There is nothing in the judgment which stands in the way. You will be advised to withdraw the application
and then go directly.
and go and challenge those individual orders where you have a problem.
Right.
If you will definitely reserve the liberty to. You have that.
Right. So your lordship may keep it on another date. I'll get back to your lordships on this because we do not also want a situation where, my lord, before this court it comes up before a smaller bench, which it will, and my lord, that bench would be then bound by five judges. Yes.
Badri, one thing more.
Yes.
Any immoral conduct
Yes.
of an officer in his official duties or as an
He would have read this, had those orders. But to the best of my knowledge, my lord, there is no such matter. In fact, yesterday one of my matter was dismissed and held that misconduct because of adultery, and his dismissal.
That's why we say that a case-to-case examination is the only way out. A case-to-case examination cannot be done in a clarification application without the parties. It's a totally different thing.
Both of you
Both
of you counsel are aware of the pain, deep pain that adultery creates in a family. We have held so many sessions as judges in the high courts, habeas corpus jurisdiction, and we have seen how families are torn asunder with adultery. I mean, this is a thought, we thought, we should keep to ourselves, but we are just telling you, don't treat it in a very lighthearted manner. If you have experience, what happens in a family when adultery takes place?
Families are broken.
Completely broken. And children, I recall one incident. There were two children. Mother committed adultery, and she filed a habeas corpus. She wanted to interact with the children. They came. They were 13 and 11, I think. They even refused to talk with their mother. I tried my level best. Such a, it really broke my heart on that day. That's a kind of rancor, that's a kind of hatred, the kind of, even violence as it happens.
And it's still a ground.
That part of it has been taken care of by Joseph Shine itself, and that has been retained as a ground for divorce, even in Joseph Shine.
That's right. You
We are concerned. We are concerned. None of these sections, Your Lordship, I appreciate, is connected as in nexus.
Joseph Shine, that's not based.
My lord, I filed an application for placing certain important documents on record, my lord.
Let me censor on that.
IA number 12131401.
First of all, let her see whether she is going to press the application. Otherwise,
Right.
Yes.
We can give this.
Lordship, kindly fix a date for that.
This is a small matter. It shouldn't take.
No, it won't take very long.
We can have it on the 16th, where we have put that matter like this.
16th of Your Lordship is intending it.
6th of December is ideal.
All right, very good.
Yes, 6th of December.
Would,
Yes.
would my lord just, I would just.
Including, my lord, the question of maintainability, Your Lordship, here on that, my lord, if the sender is not withdrawing it.
Yes.
Because we have serious issues with respect to its maintainability. A review petition was earlier dismissed. It comes, my lord, after the dismissal of the review petition.
They are only concerned with
Let
the
us see,
armed
let us see, let
forces.
us see.
I would just request them to supply, just to provide us with the orders with AFT, because to my best of my
You
knowledge.
request, why do you need a court's order for that?
Obliged, grateful.
Grateful.
They were having clash. So they came here, I told to manage.